Well, good morning and thank you very much for joining us. I am Iori Folarin. The big news of the day, of course, is like an update. It's a story we've been grappling with for long. The amended electoral bill has now been signed into law by the president. And let's talk about it. The main plank of that bill is that the much discussed Section 60, which talks about whether or not results shall be transmitted real time. That's been resolved now. Senate has always said that it has nothing against the transmission of the results, but the issue of real time is what needs to be looked at very, very seriously. As it is, the results will still be transmitted, but the real time has been removed. Where it fails, that is electronic ability, where our compliance is such that we cannot be compliant, we don't have the bandwidth to send it immediately, then we revert to Form EC8A, which is the first record, the very first record of election results. Okay, but to look at this, not everybody is on the same page on this whole matter. It needs to be said. There are those who have, vehemently said that, no, it must be real time or nothing. Well, my guest this morning, Malaki Ogumadu, is a constitutional lawyer and former president of the CDHR. Thank you very much for coming on the program.
Thank you for the opportunity again.
As always, our pleasure. So, that I think summarizes it briefly, the situation. Many people say that, now all technicalities have been removed. You don't want to give legal gladiators unnecessary grounds to come and practice their core art. Look, if it can be done, it will be done. If not, nothing spoil, as we say locally, nothing spoil. Both, by implication, both are still good. But you cannot now say because it was not done real time, any part of the law has been infringed upon. But how do you see it?
Well, thank you again for having me. For me, it is, I think we have to first accept where we are, namely that the bill has now been passed into law by the assent of Mr. President yesterday, the 8th of February 2026. Now, that is the law. But that doesn't reflect the desire of the Nigerian people who have managed within the space of time when this became a hot issue, a national issue, to demonstrate what they wanted, what they believe should be able to take into consideration the very recent experiences that they have had. And those experiences are not just experiences that were localized or isolated in the polling units and in the processes. They were experiences that even the Supreme Court of this country could not resolve. The Supreme Court was hamstrung. This very issue came to the Supreme Court, and the Supreme Court is unable to deal with finality the question that came to them on the ground that they took the view that what is contained in the electoral guidelines of INEC and their regulation cannot approximate what is contained in the Electoral Act. This is with respect to the 2022 Electoral Act. So we felt, Nigerians thought that this was yet a golden opportunity to now draw from those experiences and those situations and deal with this matter once and for all. The question now is, in the wisdom, I hope that wisdom is sufficient enough to really be characterized as a wise decision. In the wisdom of the National Assembly, as presented,
representing the people.
Representing these same people who are protesting. In fact, there are some who have gone ahead to say that this is a coup against the people you claim you are representing, because they have spoken out in the very manner that they could and within the constraints that they had in terms of organizing much more than they did, to say, yeah, please, it is we you are representing.
Mm-hmm.
This is how we see it. Now you've gone ahead and in another swift, very swift manner, that amendment, as they passed it, became got the imprimatur of the president, the assent of the president, sealing this matter as far as the law is concerned. What the Nigerian people were saying is as simple as, let us deal less with human influence in these whole processes. Our experience has been that this human interference at every turn and curve of the process is what has depleted the integrity and credibility of the process. i.e., where results are announced at the polling centers or polling units, as the case may be, every person sees it, party agents are there, security operatives that are statutorily mandated to be there are there. Why then does it assume a different form in content at collation centers, where the same results that were seen, verified, and signed off at polling unit becomes a different thing after collation?
Wait a minute.
Sorry, let me just light on this point.
Okay.
It is to deal with that that Nigerians have now come out with this innovative idea of transmit what is contained in that form EC8A to your own portal, just so that there will be a secondary data containing this same primary data that you have.
And the Electoral Act doesn't have anything against that. It doesn't speak against that.
In good time, what they have.
It doesn't speak against that at all.
No. What has become the caveat and has introduced the anger and fear of the people is that it is now at the discretion of the officers on ground to determine when that can be done.
Okay, now
this is the problem.
This is where you can help me a bit,
yes,
because I didn't have that understanding that
it is at
the discretion of those officers on ground. It is the understanding I had.
The word of real-time, instantaneous transmission is not contained in this.
Because
this bill that is passed as an act now. Because
in their wisdom, the legislators, in their wisdom, as you put it,
I have queried that wisdom.
Have seen that
with that wisdom. We will tolerate it.
In their wisdom, they have seen that you can't guarantee instantaneous transmission.
Very good.
The president, in his own comments, as he was about to sign this thing, he had said so, that you can't guarantee. But we had known earlier that Form EC8A is the very document that a scanned copy of which will be uploaded.
First of all,
everything depends on Form EC8A.
Agreed.
The first record, I understand, the very first record that is done in public with numerous witnesses, that is what is recorded and subsequently scanned. Now, whether it goes, as we say, whether it goes is another matter altogether. And where that is a case, where that becomes an issue, then we have EC8A to back us up. So as the president was saying, perhaps maybe we should be querying the bandwidth available to us. Who does not know that we have bandwidth issues? You know it. I'm talking about you bank, and you know how many times have you sent money and that it has not landed, but it has left your account. So as far as you are concerned, we have done the needful. But as far as the recipient who is expecting it is concerned, nothing has happened. So this is a big issue, and this is what the Senate said has been removed from the equation. We will not be in any loss, whether it goes or whether it doesn't go. We will still send it, but we can always fall back on EC 8A.
Thank you. Can I now respond? I see the much you have done to re-echo the views of both the National Assembly and the President. And
the majority of people.
No, if
yes,
you say majority of people.
Yes,
then,
because you said majority of people for your point of view.
So if you say majority of people, then there won't be noise out there. Why are people protesting?
Because majority are speaking. You said no. Most people.
No.
And now I'm saying most people don't see it like that.
If you add the number of people in the House of Representatives, together with the 109 senators in this country, they cannot get to 1% of the population of this country. So when you are talking of majority, including the president, even the presidency, it cannot.
So where do you get your where do you get your own most of the people from?
Oh, my most of the people is the masses of this country. Just a moment. Represented by the civil society, represented by the professionals, represented by all the people you saw on the street in the last fortnight, explaining that this is the view of the people of this country based on their experiences. But let me don't distract me from the
because when you say majority of the people had their say.
Okay.
They were allowed to have their say, but you can't say it was a mass. It wasn't a mass action. It wasn't a mass movement.
Let's leave out.
But it was recorded that some people protested.
Let's leave out that majority.
Yes, let's leave out most.
I agree with you. Let me have the opportunity to respond to the concern that you have. First and foremost, it is a big indictment on the president, our dear president. Don't forget, we were comrades, we were colleagues in the struggle. I was the deputy national secretary of JACON all through that mad period, even if I was just barely 23, 24 years. I know him. It is a big indictment on the president of our country to say that why the rational thing cannot be done is because there is no guarantee on the bandwidth with which this can be effectively and effectually done. That is one. The second point is that he re-echoes the sentiment of the lawmakers, House of Reps, Senate, thereby fortifying their position that we don't yet need transmission of electronic results instantaneously and in return.
Sorry, I must beg to differ. He didn't say we don't yet need. I think he implied that we
have the infrastructure.
We are not. How technically compliant are we today?
In other words, we don't have the guaranteed technical infrastructure
dealing with actuality.
So I am not missing that. It's not lost on me. So let me land with my thoughts. Now, in this country, on record, these are politicians talking. In fact, from the majority, from the ruling party, because we have seen, I'm sure you won't say that didn't happen. Opposition members of the National Assembly at a point walked out that this cannot be what they want, what they agreed, and what their people whom they are representing are insisting on, and they walked out. Therefore, if where we are is that people want to take care of an experience, a practical experience they have had in recent times, one would have imagined that it required the creativity of the same state actors in the capacity of legislators to get around it in a way that reflects what the people want. And I give you one practical example why they would have done that very easily. In this country, on record, the agency that has not just the responsibility, but the expertise to determine the efficacy, yes, of this infrastructure they talk about. When you talk of bandwidth, you're not just talking about 5 gig. It can be 2, it can be 3. It's relative. What that agency gave as a report, still verifiable, is that you have more than 95% capacity.
95% compliance.
Compliance.
Technical
which is the same compliance that this, which is the same compliance that Mr. President is complaining about. The agency, except it is being denied, it cannot be denied because it's a record that is available and verifiable. What is more, those who have had the benefit to work in the same INEC and who have had first-hand experience.
And here you're going to mention our friend Mike Igini.
Mike Igini has proven to be a patriot in this country,
yes,
and a hero,
without
and an authority.
However,
with respect to issues of elections and electoral processes in this country.
Arguably is not
It is not just Mike
majority.
Igini. I have listened repeatedly in the last 2-3 days to a colleague of Saze Uzi, who was a former Attorney General in Edo State. In fact, I think this morning he was also one of the, and all of these people are saying, wait a minute. In short, in the case of Mike, he said he has just realized that he has wasted a complete decade, and I congratulate him. The same thing that happened to me in the university. So
you see,
if all of these facts are available, and we're burying our heads in the sand, playing the ostrich to pretend as if these records don't exist, then the problem will continue.
No. When you say playing the ostrich, it means we're looking away from the truth. We're burying our heads in the sand.
So what are the truth here, sir?
The truth here is that...
We are talking of the report of NCC.
The truth
is it not the truth?
The truth that must be considered
that we
is
have
how technically compliant are we to do what the earlier version of the Electoral Act amendment said, which is that you can send it.
So those practitioners of INEC are surprised why it was...
We're going to come back to this, but we've got to take a quick break. Do please stay with us. We're not going anywhere. We'll be right back. Okay, welcome back. We're talking about, we must talk about it. The deed is done. The president has signed. It has become law. Mandatory real-time transmission is not on the cards anymore. transmission still, but not mandatory real time. I understand that Reverend Dominic has joined the conversation. Good morning, Reverend Dominic.
Good morning to my friend in your studio.
Yes.
Can you hear me?
Yes, we can hear you, Reverend.
Okay. Yori, I'm so glad and pleasantly surprised that you brought this topic in TVC. God bless you. Now, let me say this, Chief Yori. What this bill has done to us was taking us back to 2015. You're going to be my witness. In the 2015, we have issue of incident form. We have a proposal. What the machine did not work. That the electoral officer can record you incident form. Now, that day, all the instruments to record and satisfy who is a voter failed all over Nigeria. And the electoral officers will return the governors with incident form. That is what these providers have done. There will be no network in 2026 or 27 because of the already leeway that where there's no network, you can return back to the other one. That proviso is injurious to our progress, sir. And I want to say to my president, which I love so much, the man who is a winner, the man who is a strategist, that's Ahmed Tinubu. I can't believe what he said the other day, honestly. I was cleaning my ear. How could Mr. President indict himself? There's no broadband in Nigeria, which is governed. If there's a broadband in 2022, by what your guests have said, NCC or what came to tell us they have 95% coverage. By 3 years ago, it means that my president could not take it the broadband from 2022 to 95 to 100%. Why should he say by himself? That was not good for me, Mr. President's tongue.
Okay.
Number two,
okay, number two.
Documents have gone to Afabemi, the attorney of this nation. The story were different. That man is a thorough professional. But I don't know how Mr. President could sign that thing so fast. He couldn't take it to his attorney to advise him. What is the hurry, Yori? What is the hurry? Is Mr. President senator or House of Reps? What is the hurry? I don't know the hurry. For the first time in 1989, no president has signed the electoral law. 24 hours as it was signed, and was sent to him. Buhari rejected this almost 2-3 times. Obasanjo did the same thing. Why should Mr. President sign this bill? To me, somebody told me, it's a reverend, maybe Mr. President was waiting in National Assembly to sign this bill. If this bill not get to Asura, I don't know the hurry. There's a broadband here, Yori. There's a broadband in the nation. We have it in essence, but this bill has taken us back to 2015 of incident form. It's unfortunate. God bless Nigeria.
Thank you very much, Reverend. Thank you very much. Mandatory real-time transmission. When people talk about electronic transmission, mandatory real-time electronic transmission, the point has been made by experts that, first of all, everything about our election is manual. Let the word electronic, let it not confuse anybody. Everything is manual. You vote manually. It will be collated manually, and all of that. It is only the transmission that is the electronic part, and that can be a problem because there might be technical issues, whereupon it would seem as if that which the law stipulates has not been achieved. And so let's take that out. But when we say we take it out, it doesn't mean that we've cancelled it. It means that should it fail, it is not a failure because there will be Form EC8A to still, be the form of record. That, I think, is what most people say that's the way to go. No. Some also say, as you have said, some also say we want to insist on mandatory real-time electronic, but it is some, not most.
Mr. Yori, Uncle Yori, we proudly
please,
call you
Yori is even better. Yori is just better.
Now, if we were to remain where we are, because it is comfortable, it is more convenient,
Well, we're pragmatic.
These are, I've always told you that lies are better told in English. From pragmatism to realism to, these are all,
it is pragmatic.
But let's break down this a bit. Perhaps it will help us. I've made the point, the preliminary point, that the law now is that instantaneous real-time transmission is not part of the amendment. That is cleared. Did we desire it? We did. Were there voices? And I'm proud of Nigerian people. In fact, as a member, as a leader of the civil society, this is one very proud moment that I have experienced. Within the space of time, both in terms of the logic and in terms of the work that went into these observations. For our collective, I'm really proud, and I had cause to mention that even in the meeting we had yesterday, to say we need to congratulate ourselves first on that score. If we were to remain where we found ourselves, there won't be need for governance now. There won't be need for voting. Why would we be bothering ourselves? It is because as human beings, we aspire to improve.
Yes. Yes.
So if we have had manual processes,
yes,
defining our electoral activities and behaviors,
and it is our wish that we should be beyond that.
Correct. And we have come out so poorly in terms of the outcomes, for which reason, and for legitimate reasons too, you have contestations in court. Then we should, as progressives, the man is a progressive. And so they have progressive governance forum.
So
the point we're making, therefore, is that we needed to advance these processes to get to and reduce human interference that occur through these manual processes you talk about.
Okay, I hear you, sir. I've heard you. But there are no human interference if Form EC8A is still there, signed in front of everybody, koro. It is Form EC8A that is going to be uploaded.
Of course.
That is what is...
So the problem has always been that...
You can't adjust that.
Even without Form EC8A.
You can't adjust it.
Things have always happened at collation. And that thing that happened at collation that brings about the discrepancies with this primary data, this primary record, is what we want to take care of through this electronic transmission. That is the argument.
Okay, I'll come back to studio, but I want to take on Mr. Odunlami, who has called in from Lagos. Good morning, Mr. Odunlami. Odunlami, good morning. Can you hear us? Apparently not. Mr. Odunlami in Lagos.
Good morning, Chief Yori.
Good morning, sir. Go ahead, please.
Yes. Chief Yori, good morning to you. And good morning to your guest, a man who I've always loved to listen to.
Malaki Ugumadu.
Two critical words are the issues here to me. Real time and mandatory. Now, to your guests, I have these few questions. If the law had insisted on real time, and we have one or two failures as we would normally expect, even if you don't agree with the president that we have issue with bandwidth, would that not amount to disenfranchising some voters? Because if everybody cannot, if it cannot be transmitted in real time, what becomes of the voting result? The second one, which is mandatory. If the law had insisted on mandatory electronic transmission, what happens if, for example, there's no data, there's no bandwidth, and some people could not vote? What will happen to that exercise? Would that exercise be a nullity in that particular polling unit and several polling units as you might have it? So these are the posers. We may not agree entirely to what President has signed to, but in reality, I think it's just what our environment can get and what we can fly with. That's my take, sir.
All right.
Well,
very intelligent.
Thank you very much, Mr. Odunlami, for calling in.
Thank you, Mr. Odulami. I think even the state of the law now has dealt with the first leg of your question, of your PUSA, because it does not, the law as it stands now does not speak to instantaneous real-time transmission. In other words, the transmission, nonetheless, must happen. But where there are technical challenges, then you fall back to the form EC8A. So that, for me, has taken care. The concern now is with respect to the second question that you asked. That is, will the failure to transmit real-time invalidate the votes of Nigerians? Will it amount to that? For me, it is either of two things. The one is that we are no longer in that instant, assuming the agitation of the Nigerian people scaled through. We are no longer confined to from EC8A. We will be talking now of the results that were electronically transmitted real time. Now, if that becomes contentious and any person on the basis of that challenges what has happened, either maybe the one who loses the election, the court will now have to deal with that situation as it is in the Electoral Act. Don't forget, I made the point that even the judiciary was hamstrung with respect to this matter. Why? Because the apex court said there is no way we can accede to your argument because what you are contending is not contained in the Electoral Act.
So now that has been fixed.
That has been fixed. But without the real essence of it, which is the mandate. You added that codicil. Is that what you lawyers call it? No. Codicil is with will. We are not discussing. There is nothing ambulatory here.
You added that one.
That's the point. That's the point I have been making. If we have a problem, the courts will have to deal with the real issues as we desire it. In the first instance, and in the time before now, the court did not have the opportunity to determine what we were contending, namely because that issue is not contained in the Electoral Act.
So
now the court will have
simplified things down.
Yes.
Ideas have been simplified down now.
In the sense that it is there now in the Electoral Act. What is not in the Electoral Act is the instantaneous transmission of those results up to the IREF.
So you cannot infringe on that. It's not there in the Act.
My position,
no lawyer can come and plead that subsequently.
My position is that even the word real time, even the word instantaneous, even the word immediately are relative terms. Let the court be able to determine that just a moment, let me land on this. That responsibility of transmission occurred. Because before now, they were not obligated to do it. So if you did it, and it is confirmed by the party agents, by the security officers who are there in the polling unit, by representatives of the people, it will mean that you have satisfied the law. If it happened 20 minutes or 1 hour or 15 minutes after that time, that should be what the court will be able to determine.
Thank you, as a lawyer and a highly experienced one, you've just provided a scenario of what the law can now look at.
But not to remove it. Let it be there.
Let the problem be there.
No,
let the potential problem be there.
Well, because
let the potential problem be there.
Because the political elites have refused to accept what the NCC is saying. Namely that we have enough to guarantee this instant transmission. In fact, by their
we have enough bandwidth.
By their report, it is that.
Report, what date?
It is
what date?
2018.
2018. We're in 2026 now. Everybody uses internet.
In other words, by now we ought to have gotten 100%.
Okay.
And that's why they're calling it an indictment on the president. Who is saying,
we're going to be right. We're going to be right back. And indeed, please do keep your calls coming. But we take a break right now. We'll be right back. Stay with us. Okay. Good morning, Mr. George. Are you still there?
Yes.
Okay.
Can you hear me?
Yes, we can hear you. Good morning, Mr. George.
Good
Go
morning,
ahead.
and good morning to Malaki.
Mr. George, good morning, sir.
Uncle Yori, I'm surprised at some of the statements I'm hearing from my respected friend, Mr. Malaki, this morning. He said two things. One is that the people of Nigeria were the ones protesting at the National Assembly, and that he represented the majority of Nigerians. That is not true, with due respect to him. My man on ground in Abuja took a count on the number of people that protested at the National Assembly, and he counted 132. 132 people cannot be speaking for 230 million people. Those who voted, for example, in the National Assembly, the Senate, 15 people voted against, and 55 senators voted for it. Does it mean that the senators are not representing the people? Then, in the House of Representatives, 114 members voted against. I know there are 260 people there. The rest, 200 plus, voted for it. So it is not true that majority of that those people were speaking for majority of Nigerians. They were not. We know them. Now, I want to ask Mr. Malaki, what is the difference between transmission and instant transmission? We did not go to the same place. In the last election, there was transmission. Transmission was still going on about a week or more after the election because of technical problems. Is my friend Malaki saying that Nigeria has no technical problems in our communication system? So if you make a law and you say this must be transmitted instantly, and for whatever reason it is not, the officer is not able to transmit it instantly, it means the election for that area is not taken into account, and you have disenfranchised a lot of people. What I know I can see these people doing is they are already crying that they have lost an election. We know what many of them did in 2023, attempting to hack INEC website. What they are trying to do in this one is they want to make sure it doesn't work or disable our communication systems at that time. So confusion will come. When they go to court, to say it was not transmitted, instantly.
Real time. It was not real time. It was the mandatory real time transmission.
That we want.
Yeah. Okay.
We have to,
thank you very much, Mr. George. I think the bulk of the idea, is with us now.
All right, it's done, I suppose.
Yes.
Mr. George, in the same way, I have very high regards for you. It's been years, even if I have not met you I don't even know how you look. You have the privilege of at least knowing me if you see me on the road. But here is the point. Just with respect to the first observation you made, namely that you have somebody on the ground at Abuja who did a head count of those who were protesting. Let me tell you that the protest was not only at Abuja, and it was not only on that day.
Yeah, but you're making it sound like a mass protest. It wasn't. It wasn't.
And I have said I congratulated my people. By the way, let me put it very straight. I am in the civil society. I'm not a card-carrying member of any political party, and none can hoodwink me into their own game, even if at some point we might seem to be saying the same thing. Please get that very straight. And it's been for years. So I'm aware that there were even press conferences here in Lagos preceding that time. And if you recall, Mr. George, because you're quite vast, the way you talk and the experiences you bring to bear on national discussions, you know and you remember that even the House of Representatives, the Green House, already has a version of their bill which supported this real-time transmission.
Yes.
It was because it worked at variance. It was in conflict with what the Senate had passed in their own chambers, that the need for a conference section was proposed, if you remember.
Yes.
So
they needed to harmonize their position.
I was taken aback. I didn't understand why the same House of Representatives that had passed their own version reflecting what the Nigerian people wanted, somersaulted, and then toed the line of the Senate, clearing the way for the assent of the Mr. President. Look, I'm a Democrat. I believe in the due process. I understand what has happened, and I know where we are now, which is why I said, as far as the law is concerned today, the 2026 Electoral Act does not have real-time transmission. We are saying what would have been best for us, drawing from our experiences, drawing from the hiccups we have suffered, drawing from you, Mr. George, will recall what has been happening in the past when there was such lacuna and discretionary powers of the electoral officers to resort to incident form. It became the norm because in most cases, the beavers could not walk, thereby justifying the resort to the incident form. It is those kind of things that were, targeted to be able to be taken care of.
So you are saying that, because I'm trying to understand you, you are saying whatever the problems are of the attempt to mandatorily transmit in real time,
yes,
leave it in there.
Yes.
Warts and all.
Yes.
Let it all be in there.
You know the reason why I
and
put
then
it that way?
The courts will sort it out
deal
later
with,
on.
yes, we'll
as opposed to cleaning up the whole system.
And that cleaning you mean is what?
That cleaning.
So getting to the bandwidth that the president is talking, in what year?
No.
When?
Because we don't have the capability yet.
So when you speak, because that is the narrative that has been presented to us, and we're swallowing it hook, line, and sinker.
But we all know that we all know that we can look at our electronic, our internet compliance.
See, that's why I say this is a relative term. If you say real time, whatever, 5 hours can be real time. 2 days can
No. Sorry, sir. 2 days cannot be real time. 5 hours cannot be real time. Real time is that the moment you are pressing the button here, it responds and it transmits all over the place.
Brother, I speak as a lawyer, and I'm saying.
You're saying that in law?
Yes.
Real time can be 2 days.
It is relative.
Real time
in relation to every other time.
But even you lawyers even allow that some things are open to commonsensical interpretation.
Well, I don't know how far I can go with you.
There are aspects
on
of the
this.
law where they will say, the law has a different take. But common sense is allowed to. Real time, I don't see how real time can be defined as 2 days later.
No.
Can real time be defined as 2 days later?
Why are you not mentioning the 5 hours that I talked before? Even 20 minutes.
Can real time be determined, be said to be 20 minutes later?
Yes.
Can be real time?
Yes, because it's relative.
Okay.
It is relative.
Okay.
And that relativity is against the backdrop of every other variables that must play out there, including this network we are talking about.
Sorry, sir.
And therefore, if the electoral officer...
Forget my simplicity. Yes. If I am viewing you in Ikorabasi, and you are also viewing me, and you press that I have sent 500 naira to you, and I see you, and my device does not have the 500 naira coming in, that was not real time. It will come in, because I trust the process, it will come in 5 minutes later, 5 hours later, but it's not real time.
Well, I mean,
I just wanted to simplify it down to let simpletons also understand this elevated argument that you are making.
That's fine, that's okay. But I have made the point that real time in relation to this is a relative term.
In relation to the elections, to this electoral law now.
In relation to all the associated factors surrounding that process, including the bandwidth, including the infrastructure you are talking about.
Let me find out if Mazi Okorafor is still with us. Mazi Okorafor, are you still with us? Mazi?
Yes, I'm still with you. I'm still with you. Mazi Okorafor.
Okay. Okay, jump in on this topic. Go ahead, Mazi.
The law which the president has signed, at least the attitude have been buried. No longer the electoral act of what that delay the election, delay the tribunal, delay the passage of anything. But the question now whether clause A or clause 149 or 146 or anything will talk.
No, it's only 60. Let's stay on 60.
For Nigerian political parties and the politicians to go straight back and bring this act to the level of Nigerians in their local languages, in their communities. So they will know exactly what the act is talking about. Each one, transmission of results and transfer of results. There are two things there. So the area these people mentioned now are part and parcel of the education or passing of the message to the grassroots is better. But the question now is this. In as much as our level of literacy is high, and the social media and the journalistic freedom or journalist news we normally have, and they spread more news more than the television houses or radio houses or any media houses. But the thing, Nigeria has to take it coolly. Sit down, see how you can solve this voter apathy. Voter apathy is the major problem Nigeria should be talking about.
Okay, Mazi. Thank you very much, but you're going somewhere else. You're bringing something else in, but we do appreciate your calling in. The point that the learned lawyer is, explaining here is his understanding of why removing mandatory real-time transmission is not to the satisfaction of some people. In fact, he even said most people, but I contested that. But most people are saying that the removal of that mandatory real-time transmission, which lawyers can work with, let it be known. We've seen lawyers, do their thing. Mandatory real-time transmission, it's very easy for legal minds to, almost invalidate a given electoral process. Now, that has been removed without removing the fact that the transmission part of that expression, mandatory real time, the transmission part is intact, but the mandatory real time is what could cause a problem.
So if these legal minds that you eulogize and elevate to almost the status of demigods are confronted with the fact that the transmission occurred, even if it did not reflect instantaneously.
And it wasn't real time.
The transmission had happened.
Yes, and that's why EC8A,
that's why I said,
EC8A is
just
there.
Just a moment, maybe if you hear me completely, you will understand what I'm saying. So the law says, transmit real time. And that responsibility...
Well, said. It doesn't say it anymore.
Oh, well. Well, I'm assuming that's what, because that's your challenge, that it were better that it's not there because
they removed it. The National Assembly removed it.
Assuming it's there, I'm clear about what the law is now. It's not there. But what we're saying is that I personally would have wanted that it is there.
Okay.
And therefore, whoever has that challenge of saying that real time did not happen with respect to this, and you're able to prove that it was just 2 minutes after the signing off of the from ECATA that it was transmitted.
Okay.
Wouldn't that be the real time we're talking about? This is it. We have agents, we have party agents, we have security men. Immediately after that,
transmission will have a beginning time.
So it's a process, yes.
It will have a beginning time.
So that beginning time is what you have done. In other words,
so if you transmit at 9 o'clock.
If you transmit at 9 o'clock and it delivered at 9:05, I am saying that is real time.
Okay, well, this is...
because it's a relative time.
Well, this is an additional understanding you are giving me.
That's what I have always been saying.
This is an additional understanding you are giving me of what real time means.
That's what I have always said, that it is relative. Okay. And that's why I say it can be 2 seconds, it can be 5 minutes, it can even be much more than that. But once you have discharged that responsibility of activating the transmission, in my view, you have done it.
Okay, I'm happy.
I'm
happy you said in your view, sir. Yes. Because there will be other lawyers that nobody will be surprised having a contrary view.
Of course.
Nobody will be
surprised. We will
surprised.
go out of business if we all agree. Even the pastors don't agree with the same verses of the Bible.
But exactly. So I guess it's a very interesting conversation. The law is the law now. Yes. It's been signed into law.
Yes.
I think the law is counseling us to be aware of technical limitations.
And I have indicted the political class and elite, starting from Mr. President, for reminding us that we don't have enough bandwidth to go back to where we were before this time.
And the first time,
sad commentary.
The time when the NCC, I think you said it was 2018, and here we are in 2016, 2026.
Which means we would have recorded 100% of the bandwidth.
In 2026, nobody is going to stick his neck out and say that you can do instantaneous real-time transmission. Nobody's going to stick his neck out. Banks know it.
If we have
everybody knows it.
You have up to 95, 97%.
Yes.
We ought to run with it.
Okay, indeed.
Otherwise, we also cancel electronic transmission in banks and refer back to the tally. You call it tally?
Tally number. Give me my tally number.
Now you are scared of transmission.
We're going to have to leave it here. It's been quite interesting to hear your take on it. But nothing, people might say, nothing spoils in the sense that the transmission is not taken out of the law. It's the mandatory real-time transmission that has been taken out, and that was for the sake of pragmatism. And you have said that that is unsatisfactory to a number of people.
Because that lacuna, that space, is where the manipulation occurs.
Well, thank you very much, Malaki Ugmadu, constitutional lawyer and former president of CDHR, for coming along to air this particular view. We have the amended law. We have a law. The Electoral Act is now of 2026 as amended. That's our program today. Do please join us tomorrow for a fresh edition. I am Yori Folarin. Bye-bye for now.